Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. In Quebec recently, the chief firearms officer went on a bit of a spree, revoking firearms licenses and refusing some pending applications for people connected to certain motorcycle groups. I had a lot of people asking me, wait a minute, can they do that? And as it turns out, there's a whole lot of cases on this, but let's just look at one of them. And the reason why I want to look at this one is that it sort of goes along with the typical pattern, and it illustrates it, in my view, really well. This is a recent decision. This is the case of Enns and Alberta, Chief Firearms Officer. And so let's have a look at what's going on here. They note the applicant, Patrick Enns, is a motorcycle enthusiast. Now, Patrick Enns is the applicant in this case, not because he was applying for a firearms license, but because he's now coming to the court and he's the one who's asking the court to do a thing. In this case, in this Section 74 review, he's asking the court to overturn the decision of the firearms officer. So that's what makes him the applicant here. He's also a member of the Unforgiven Motorcycle Club in Calgary. He applied for a firearms license under the provisions of the Firearms Act in a decision entitled Notice of Refusal to Issue a Firearms License. Firearms Officer Pat Weisgerber, in his capacity as a designate for the Chief Firearms Officer for Alberta, denied the application. Mr. Enns now applies to this court for review of that decision. So again, this is a Section 74 hearing. He's wanting to review it. I'm going to link this case below. I'm not going to go through the notice of refusal in this video. I will probably do so in a future video because one thing I really like about this case is that it actually includes the notice of refusal so that we can look at it and see sort of what should be in a notice of refusal, and so forth. That will have to wait for another video because there's a lot to this case and I don't want to make a 3-hour-long video because everyone will be asleep by the time it's done. So continuing on. Now they start out with Pogson and Alberta, which is a case. The main thing that comes out of this case is binding case law, at least in Alberta, on what the standard of review is. Now, standard of review is super important, but it's also super boring. What standard of review means is it's the test that a sort of appellate or higher level court uses to determine when the threshold has been met in order to overturn the lower court's decision, or in this case, the decision of the Chief Firearms Officer. Super important because cases are won and lost on standard of review. However, super boring. So I'm going to summarize this really quickly. The standard of review for these Section 74 things is a little odd because there's multiple standards. So the first standard is that if the evidence that's before the reviewing court is basically the same as the evidence that was before the firearms officer, then they're going to go with a reasonableness standard, which is fairly deferential. They're not going to overturn it just because the judge would have done something differently. There has to be an indication that the firearms officer was clearly wrong in some fashion. However, that standard drops a bit if there's new evidence that is of significance. So it isn't just like, oh, well, I was actually wearing a red jacket that day, not a blue jacket. Nobody's going to care about that. But if there's actually significant new information, then that drops the standard and it comes closer to a standard of correctness, although it doesn't quite get to that level. So moving on, we'll just have a look here. Application to this case. In his notice of refusal to issue a firearms license, the firearms officer Weisgerber relied on the provisions of Section 5.1 of the Firearms Act and said, it is not desirable in the interest of safety that you be issued a firearms license at this time. He refused to issue a firearms license to Mr. Enns. I'm going to note as well, I will almost certainly at some point do a video on Pogson because it's a great case to know if you do anything with Section 74 reviews, either because you're a lawyer or because you're bringing one yourself. It's a case you have to know if you're in a jurisdiction where they apply it. There are some different cases applied in different other jurisdictions. So carrying on. In reaching this decision, the firearms officer relied on an expert witness report prepared by Detective Dave Mills of the Calgary Police Service. Based on information in that report, the firearms officer stated in his refusal decision, police information as set out in Detective Mills' expert witness report is that you are a full patch member of the Unforgiven Motorcycle Club, a support club of the Hells Angels Motorcycle Club in Calgary. Detective Mills is familiar with the history, background, and characteristics that make up the Hells Angels, including in Alberta and the Unforgiven Motorcycle Club. His opinion is that it is a structured organization and its members are bound by rules that allow for violence and other criminal acts to be committed, that their main purpose is to facilitate criminal offenses. These rules forbid any member from cooperating with police, and you would not contact police for any reason, no matter the seriousness. Should your firearms ever be stolen, lost, or used in an offense, you are prevented from reporting it to police, thereby endangering the safety of the public. As you are a full patch member of the Unforgiven Motorcycle Club, I find that you represent the Unforgiven Motorcycle Club and the Hells Angels and are bound by the rules that allow for violence and criminal acts, and that the police are your adversary. You made this decision to be involved with an organization that has a reputation for violence and criminal acts. As such, I find that it would not be desirable in the interests of safety that you be issued a firearms license at this time. Accordingly, I refuse to issue you a license. So, very direct language. I like this kind of language in a refusal, not because necessarily I like the result, because often I've challenged them on these, but the language should be clear and understandable for the person getting the notice. So, this is very clear, understandable language, unlike some of the recent documents that some of us may have gotten. So, moving on. At the hearing of this appeal, new evidence was presented before me that was not before the firearms officer. Based on the standard review direction from Pogson, I must first determine if this new evidence is significant and meaningful evidence that was not before the firearms officer, or the evidence shows that the factual assumptions of the firearms officer were clearly wrong. And so they quote a little bit more. That significant and meaningful evidence might be evidence that simply was not before the firearms officer. I'm satisfied that there is evidence that was provided in this hearing that was not before the firearms officer. Specifically, the applicant, Mr. Enns, testified before me. It appears he had not been interviewed by the firearms officer as part of his application for a license. In that sense, his testimony before me was new evidence that had not been considered by the firearms officer in making his decision. He testified that, although he's still a member of the Unforgiven, that doesn't mean he supports the Hells Angels in any way. And he also testified that he was involved in a motorcycle accident and did make reports to the police, which counters their statement that he would not contact police for any reason, no matter the seriousness. And so what we have here is Detective Mills notes, he says that he sort of backs away from his statement and comes up with a new version, which is the gist of his evidence before me on this issue was essentially that an Unforgiven member may contact or provide a statement to police if to do so would benefit him and not negatively impact another club member. So now he's walking that statement back. That may impact his credibility, but not enough here, I don't think. So we'll have a look. So the main thrust of this new evidence relates to one of the reasons for the firearms officer's refusal, which is that he wouldn't contact the police for any reason, no matter the seriousness. And so the court determines that this is, in fact, not sufficient or not significant and meaningful in a way that sort of changes the standard of review. In addition, there is the expert report of Detective Mills, where he expressed the opinion as to the purpose of support clubs to the Hells Angels Motorcycle Club, and that Unforgiven is a support club to the Hells Angels. Enns also acknowledged that a rule of the Unforgiven is that police officers or other personnel connected to law enforcement are not welcome in the club. In his expert report to Weisgerber, he advised that the Hells Angels have a rule against membership by law enforcement personnel that is remarkably similar language to the Unforgiven rule on the issue. He also acknowledged that he wears colors, i.e. a vest with insignia and arm patch, that bear striking similarities to the colors worn by members of the Hells Angels. He attends Hells Angels events such as pig roasts and bike rides. He associates with members of the Hells Angels. As a member of Unforgiven, he and all other Unforgiven members pay dues to the Hells Angels Defense Fund. He acknowledged that the Hells Angels Motorcycle Club lends support to the Unforgiven Motorcycle Club. In view of all this evidence, including the original expert report of Detective Mills, the conclusion by Weisgerber that there is a close association between members of the two clubs and that members of Unforgiven lend support to the Hells Angels is entirely reasonable. I reject Mr. Enns' assertions to the contrary in his evidence before me. So that's not great for Mr. Enns when his evidence is being rejected. The second aspect is in relation to the motor vehicle collision. I accept the new evidence tendered on this point to the effect that in a motor vehicle collision, he and other members of the club contacted or otherwise provided a statement to police regarding the circumstances of the collision. This is directly contrary to the assertions in the expert report of Detective Mills that members would be unable to contact police for any reason, no matter how serious. In evidence before me at this hearing, Detective Mills acknowledged, though somewhat reluctantly and only in response to pointed questioning by the court, that in view of the evidence presented by Mr. Enns regarding the reporting of the motor vehicle collision and other information, he testified he had only very recently learned he would qualify his original bald statement that Enns or any other member of the UMC would not contact police for any reason, no matter how serious. To my mind, this should be a bigger credibility hit than it seems to be, because, I mean, this is clearly wrong, and the court is saying basically that he only acknowledges this reluctantly and when pressed by the court. So it's not just like, oh, hey, I made a mistake, oops, let me correct that. He's sort of sticking to his original version, it sounds like, until the court kind of backs him away from that. So I'm not sure, but the court's not going to throw out Detective Mills' opinion here in its entirety, but this is a bit of a problem, to my mind, in terms of this evidence. So the firearms officer clearly relied on this erroneous opinion of Detective Mills as one of the reasons in his decision for refusing to issue a firearms license to Mr. Enns. He stated in his decision that Enns would be unable to contact police for any reason, no matter the seriousness. He would thus be prevented from reporting any theft, illegal use, or loss of his firearms to police, thereby endangering public safety. And that makes some sense, right? If you think about it, if somebody's unwilling to contact police, that's a problem, because there are circumstances as a gun owner where you not only should contact police, but may have a legal obligation to do so, particularly around, your guns have just been stolen. That's a place where, maybe you should call the cops and let them know, hey, these guns are floating around on the street. Please help. If the only basis for the decision of the officer to deny him a license was his reliance on the erroneous initial conclusion of the detective, that would be sufficient in my view to quash the decision, or at least refer this matter back for reconsideration. Note, if that was the only reason, but it's not the only reason. Continuing on. However, a reading makes it clear that it was not the only reason he denied a firearms license to Mr. Enns. In addition, he was called as a witness in these proceedings before me. This unique circumstance is permitted by Section 75 sub 2 of the Firearms Act, which states that they shall hear all relevant evidence presented by or on behalf of the Chief Firearms Officer. So when they say this unique circumstance, I think they mean in the context of like judicial review decisions, because in the context of Section 74 hearings, it's actually really common that the firearms officer who made the decision shows up to testify, or at least is presented for cross-examination. That's my usual experience, is that they're present, and often they'll provide direct evidence and sort of explain their decision, but sometimes they're just there for if the other side has questions for them. That strengthens their case, because if they don't have that, then they're simply relying on hearsay, and there is case law that suggests that it should be given less weight. So that's why that's sort of a very common practice. In his testimony before me, the firearms officer advised that he's aware of the additional evidence presented before me. He addressed the question of whether this new evidence presented before me would alter his decision to deny Mr. Enns the firearms license. Again, This is a big reason why they want to have the firearms officer there, so that he can answer this kind of question. The firearms officer stated that it would not have changed his decision. He testified that in his view, reporting a motor vehicle collision in which he was involved, and from which he may benefit on liability or insurance issues, was a much different scenario than reporting a crime such as theft of his firearms, or reporting if the firearms were lost or used in an offense. Stated in essence that reporting a motor vehicle collision that an unforgiven member was involved in, and where such reporting may benefit the member from an insurance of liability point of view, in no way supports an inference that that same unforgiven member will similarly report the loss, theft, or illegal use of guns in his possession. In my view, it is not at all unreasonable for this firearms officer to maintain that view in light of the entirety of the information before him. And the real big thing that they're worried about here is that those guns will get lost to some other member of, what they believe to be a criminal organization. So that's what they're concerned about here, and that's what that's sort of what's going on behind the scenes here. In addition, the firearms officer made it clear in his testimony before me that his decision to deny the firearms license was not based solely on the issue of reporting a loss, etc., and it's borne out in the original notice, which is good, because if he made up new reasons at the time, that kind of makes him look sketchy. So in the initial notice, he notes, "You are a full patch member of the Unforgiven Motorcycle Club. I find that you represent the Motorcycle Club and Hells Angels and are bound by rules that allow for violence and criminal acts." So they're worried that he's part of what they believe to be a criminal organization and that he's going to do criminal things. And hey, if you are a criminal and you have organized your life around criminality, we don't want to give you a gun. And so, that's a reasonable perspective to take. The main issue then is going to be, is this a criminal organization? Is the court convinced of that? So continuing on there. This concluding paragraph is, in my view, the primary reason for denying the application. And so the unable to report thing is a secondary concern. So the question in my mind boils down to whether this primary reason remains a reasonable conclusion. In considering this question, I must consider not only whether or what was before the officer at the time of his original decision, but also the new evidence now presented before me. So this information includes the following. Mr. Enns is a founding member of the Unforgiven. As a founding member, he was clearly aware of the mission statement of the Unforgiven Club, to the effect that Unforgiven is the support club to the Hells Angels. In his testimony, Mr. Enns acknowledged that socially, Unforgiven is a support club to the Hells Angels. You see the problem here, where he's coming in and saying, oh, we're not really a support club, but he's a founding member and the mission statement says we're a support club? How far do you think that's going to go in court? Spoiler alert, not far. Relying on the expert report, he basically states again the issue about the lost or stolen. Only members of the Unforgiven Motorcycle Club in Calgary have gone on to become Hells Angels members. Mr. Enns, like other members of Unforgiven, wear colors and patches, bearing striking similarities to the colors and patches of the Hells Angels. He knows numerous members of the Hells Angels and was observed to regularly attend social events sponsored or organized by the Hells Angels Motor Club, where both Hells Angels and Unforgiven members were present and socializing together. And in fact, they detail a number of those meetings. Unforgiven members, like Hells Angels members, do not get along with police, and the club rules of both organizations ban police from being members of those organizations. And specifically, in his testimony before me, Mr. Enns acknowledged that we, members of the Unforgiven Motorcycle Club, don't get along with those people, i.e. police officers or other members of law enforcement, which is not a great thing to be, bringing up in one of these. I mean, I'm a criminal defense lawyer. A lot of police do not like criminal defense lawyers, and I have, there are times when I will absolutely criticize some of the things that police get up to, some of the practices of police and so forth. But, I don't hate the police. There's many police that I get along with, quite well. I don't have any objection to police as a category. And so if I was starting a club, I wouldn't have a no police rule. Unforgiven members, including Mr. Enns, pay dues to the Hells Angels Defense Fund. And there's an expert opinion that the Hells Angels Motorcycle Club is a criminal organization. And they cite some cases that come to the same conclusion. This evidence, when considered as a whole, can easily lead to a reasonable conclusion that it is not desirable in the interest of safety that Mr. Enns be issued a firearms license. More specifically, I cannot conclude that the decision of the firearms officer to deny a firearms license to Enns was unreasonable. Indeed, a reference to cases from across the country supports the decision of the firearms officer that association with the Hells Angels of the nature of Mr. Enns' association is a reasonable basis upon which to deny a firearms license. So when I said this is a great case to look at, there's all sorts of reasons, and one of them is that they go and look at a bunch of other cases. I love it when cases do this and sort of go through this review process, because it's a good way to get a feel for an area of law if you're unfamiliar with it. So in the case of the Queen and Borchuk, the applicant, Kimberly Borchuk, was denied a firearms license by the firearms officer merely on the basis that at the time of submitting her application for a firearms license, she was in a common law relationship with a member of the Hells Angels. She's not a Hells Angel, but her common law partner is, and that was good enough to uphold a refusal of a firearms license for her. In Milton and Wren, the applicant, Deborah Milton, had applied for a firearms acquisition certificate under the legislative scheme then currently in place under the criminal code. So that tells us that's a very old case. And that prior scheme had wording similar to the wording in the present legislation. On appeal from the original decision of the firearms officer to deny Ms. Milton's application for a firearms license, summarized the applicable legislation. And I'm going to skip over that. But the evidence in that case indicated that she was married to a member of the Hells Angels, had met with and engaged in social activities with members of the Hells Angels, and was on extremely good terms with Hells Angels members. And so they were satisfied that the Hells Angels were a criminal organization, and they denied her a firearms license. Again, not even a member, just involved with a member. So they say, in the result, the applicant, Patrick Enns, had failed to satisfy me that the refusal of the firearms officer to issue him a firearms license was not justified. To the contrary, I find the decision of the firearms officer that it would not be desirable in the interests of safety that you be issued a firearms license at this time was reasonable. In the result, the application by the applicant, Patrick Enns, to quash the decision of the firearms officer refusing to grant him a firearms license is denied. So, just in review here, the case law, and there's quite a bit of case law on this subject, but it basically says if you join some sort of criminal organization, whatever it is, some sort of gang, that's good enough reason to deny you a license. Not only that, but if you don't even have to join personally. If you are a close associate of people who are members of that, that can be that you are, in a relationship with them, but it could go even further than that. If it's something like this is your social circle where you hang around with members of, some sort of criminal organization, then they could deny you on the basis that essentially they're worried that you're going to somehow provide guns to that criminal organization. They don't want to allow that. So case law on this is real clear. I don't know the specific circumstances of the Quebec cases, so I can't comment too much. I don't know the strength of their evidence. But assuming that they're actually going after people who are involved in groups, and assuming that they can prove that those groups are criminal organizations, I expect that the result will be very similar to the result in Enns, and that those revocations of firearms licenses and refusals to grant firearms licenses will ultimately be held up. But again, I don't know what the evidence is in those cases. I just, it could be that they're going after the wrong people. It could be that they're going after non-criminal motorcycle organizations. I'm not sure. We'll have to see as that develops. Thank you for watching. As noted, this was made in response to some viewer questions, so if you were one of the people who was wondering about this, I hope I've cleared this up. Please feel free to ask questions in the comments below. I try to read them. There's too many these days to respond to all of them, but I do try to go through the comments and see what's said. I also am going to leave a link in the description below, as I said, to the case itself, as well as to my Patreon. Want to thank my Patreon supporters at the $50 level. D-Mo, People of Canada, Sir Daniel Wicks of Alberta, Canada's National Firearms Association, and Toronto Airsoft. At the $20 level, Cameron Johnson, Kevin Fleet, and Dale Nesbitt. And at the $10 level, My Buddy Keith, Process Enns, Stephen Larson, General Counsel of the CCFR, John Robinson, TR, Roy Haddock, Fracklesdack, Jean-Alexandre Tessier, Sir Goat, Sights and Arms Limited, Chaba Hollow, Peter H., Craig Kwan, Akin Coxall, North Central Process Service, Toys R for Boys, Ian Vaughn, Milan Vrekic, Terrence Griffiths, Doug Thompson, Mark D., Brad Crooker, Jason Harrington, Lee Kiso, Mark Stout, Michelle Stotzel, Scott Sweetman, Mike Rhodes, DF, Stacey Cartmel, Tactical Advantage TV Canada, Ian S., Dave Leslie, Juan, Donald Duncan, Stefan Conquest, Darren Duell, Sean Crane, Pete H., Ian Hutchinson, Travis, BC Bushcraft Leather, John Singarty, Misa Komarevich, All Systems Go, David Moga, Ian Hijdanek, Hello from Venezuela, Taylor Delnea, Rod Guzman, Matthew Nesbitt, Conway Yuri, James Cox, Zip Ties and Bias Plies. Give it a watch if you haven't seen his channel yet. I've been watching now and it's hilarious, so give it a watch. Daniel Kang, Jean-Guy Toussaint, Richard, Brock Watts, Frog Clan Copper, Annika Blaine, Tim McGill, Jordan Delaney, Rob Butts, Chris Joseph, Grant Farquhar, and Malcolm Yogi, and Andrew Elsich. If I mispronounce your name, please let me know. I'm terrible with names, and I mean, I've heard all sorts of pronunciations of Runkle over the years, so I kind of try to get people's names right, but again, if I got your name wrong, please let me know. Anyway, thank you once again for watching, and I hope that this has sort of answered questions, because there were a lot of people wondering about that one. And until next time, I hope I've armed you with knowledge.